One of my subscribers reached out to me recently with a very important question. He's facing a domestic violence case which involves cruelty also under section 498 in India, and he's awaiting trial. Now he wanted me to help him understand whether he should disclose that in the visa application form or not. He has a prior UK immigration history, that means he's traveled to the UK before. And in this video, I'm going to be discussing examples where you would, as an applicant, find yourself in an ethical dilemma or whether you should disclose that or not, and what you should do in certain situations. This gentleman who reached out to me about his domestic violence case, the number one thing that he should be doing is saying yes when there is a question of, are you facing any pending trial in the UK or overseas? The answer should be yes. But should he answer just yes and submit the application with his documentation, which would include his bank statements, financials, and previous history? The answer is no. What he actually needs is an articulate cover letter that helps the UK Home Office see the full extent of circumstances in which he is involved, and also be supported by evidence. Because if he was to just answer saying yes, that he is awaiting a trial, and he doesn't give the full context of that in a strategic manner, his visa would most likely be refused. Another example, what I believe you should know, is a case of deception. Recently, I had a case where an employee who took a leave for visitor visa visit to the UK for say 2 weeks, he was banned for 10 years because he ordered his HR cover letter in which he was approved leaves. The mistake that he did was that there were two versions of HR leave letters. The first version had different dates, and he altered the second letter by amending the first letter by himself without confirming with the HR. Maybe that person had an alignment with the HR informally, but he failed to notify the HR, and when the UK Home Office contacted the HR, they did not see the version number 2, which he had amended himself. He had altered the dates, he had submitted something else. As a result of that feedback, the UK Home Office has not only refused his visa, he was banned for 10 years because that was deemed as forgery, and the UK Home Office takes it very seriously. Now, you must be wondering, if you make a mistake, are you going to be banned, or does it mean automatic refusal? The answer is no. There is provision in the UK law where the caseworkers are given guidance about innocent mistakes or omissions. For example, somebody wrote the postcode incorrectly and their visa was refused, but on reconsideration their visa was approved because they explained that there was a type of mistake. Now compare that to a student visa application where we had an issue where the total requirement was 15,000. The applicant only had 3,000 pounds in the account. So the friend, in the interest to help his friend to get a student visa, created a forged statement that showed 15,000 pounds as a bank statement and uploaded in the student visa application. But when the UK Home Office contacted the bank and found out that the statement did not match what was uploaded, the student was not only refused visa, but he was banned for 10 years. Now think back that before you get this decision, would you not want to undo what you had done before? Now, at the time when you are really wanting to visit the UK or want to study in the UK or want to settle in the UK, you always have the dilemma of whether you should disclose that or not. And I can completely understand that you would think, like a human being, that they would not understand my situation. I'm innocent. I've not done anything. And if I disclose that, they will refuse me the visa. I'm here to tell you, and I'm going to bust some myths, that there are certain situations where the case officers are given clear guidance in terms of criminality where they must refuse the visa. For example, if you were to apply for 6 months visa, you were convicted in court, say overseas in India, for example, and you were given a custodial sentence of 12 months or more, then there is mandatory refusal. But there are certain provisions also where they may have the discretion to grant you the visa. Say, for example, you had minor offenses in the last 15 years. When you were 18, you had some immaturity, and since the last 12 years, nothing has happened. You've turned your life around. You work, you got really good grades, you work for a top class employer, you pay your taxes, but you still disclose that 3 offenses to the Home Office, the chances are they would look at the entire totality of the application, which means they would look at your current age, they would look at your age at the time when you made that application, and what have you done, what kind of offenses, how serious those offenses were, and are you a repeat offender? Are you going to be conducive to the public good? That means if you were to be invited to the UK on whatever visa, are you going to be good for the public? These are also the considerations that the Home Office bears in mind. Now, let me take an example of where you have an uncomfortable issue. For example, that you were arrested. There is a clear question about have you been arrested when it comes to suitability grounds and criminality. If you disclose that you were arrested, but you were granted bail, you pleaded not guilty, you are being represented in the court by your advocate, and the trial is proceeding, the fact that you are disclosing that would speak volumes about you as a person compared to not disclosing. The way you disclose is extremely important, and that's why you need someone to consult and draft a persuasive cover letter for you. Don't make emotional pleadings. That will not fly. What will really persuade the visa case officer is you would write something like this, and I'm only giving as a guidance that in the interest of full disclosure under the part of suitability, I wish to disclose an important material information. I was recently arrested. I dispute the grounds of arrest. I'm being represented by my advocate. The contact details are provided, and we are awaiting the trial. It was a minor altercation, and in my view, because this is still sub judice under the court, I cannot comment further, but I am innocent and I am awaiting my day in court. My next court date is X. Therefore, I want to disclose this for a fact. This is a compelling tie that will bring me back from the UK after my visit, because if I do not attend my hearing, it will be deemed as contempt of court, and then a non-bailable warrant would be issued against me. You can provide the letter from your advocate, and you say that you chose to disclose this thing because you're an honest and genuine visitor. Besides that, you're employed, you pay your taxes. Here is the letter from the employer which confirms that I'm going from this date to that date and I will return back. That is tie number 2 as an evidence that I will return back from the UK. Now imagine yourself, if you're a visa case officer, looking at a letter that says that, look, yes, I was arrested, I'm being represented, there is no conviction yet, that means I'm innocent till proven guilty, but I have the courage to disclose this thing, no matter how uncomfortable it is. That would say that this person has solid courage, he has integrity, and he is being transparent. That is the kind of people they want to have. Now, I'm not saying that every time you write like this thing, you will be granted the visa, because each offense is different. If you provide evidence like this, the chances are that you will be seen favorably. When it comes to deception, every mistake does not mean deception, and I want to distinguish between the two. For example, you forgot to mention that your visa was refused in some other country, say China, that was 15 years ago, and you forgot about it, and they refused the visa and they accused you of deception. Then there is a provision where they can show, you can write back to the Home Office for reconsideration, and you write to them by saying that given my current passport is only for 10 years, because it's for 10-year life, I completely forgot that this incident happened 15 years ago. I take full responsibility for this important omission, but it was not intentional because I did not know that I have to provide my old passport copy also. Had I had the old passport copy, which is probably not with me right now, I would have absolutely disclosed it to you, but I am deeply apologetic about this omission, but it was not intentional. Then if you acknowledge like that, and if you make a pleading for reconsideration, the chances are they could understand that. So the chances are they would grant you the visa on discretionary basis. Now consider another situation where you were convicted, you were given a sentence of 12 months. In the last 12 months, you've served the sentence and it's been only 3 months you've come out of the jail, you're clean, and you promise you will never do this thing again. You apply honestly, you disclose that to the UK Home Office. Do you think you will get the visa? The answer is they will absolutely not grant you the visa, because there are mandatory refusal period that are right now in the UK, where if you are applying for visa less than 6 months, if you're convicted, you are in the custodial sentence for 12 months or more, for example, and it has not been 12 months since, then they will absolutely refuse a visa. In that situation, what I would recommend is wait, at least let 12 to 14 months pass after your period. Look at the clear guidelines of what the visitor visa rules are now in terms of mandatory refusal period is, how long that period has passed, then try to make an application. If you are making yourself aware of where the caseworkers have a guidance of in terms of discretion, or where they don't have a discretion, usually on the UK Home Office website they use like words like you must refuse visa if it falls under this and this criteria. Then there is you may grant visa if it falls under this and this criteria. So the where the word must is there, it is mandatory. Where the word is may, that means there is a possibility, there is a discretion, and where the caseworker would use the judgment whether you're a credible person, how serious was the offense, what was the length, what was your age, what have you done since then, and do you show good character? That are you someone who takes responsibility? Are you someone who's going to be good for the public if you were to be invited to the UK? These are some of the factors that you need to bear in mind. Now, I can completely understand when somebody gets a visa refused, it is a deeply disappointing feeling and your dreams are shattered and you don't know what to do with that. In that situation, as much as I would want you to say you should reapply, my humble recommendation is this: please do not rush. Whenever you're doing a visa application, always double check. Sometimes the immigration agents, you don't even know that they have provided a false statement. They've forged a statement which they have used it multiple times to get the visa, and that results in visa application refusal. You can say, I just provided my details to the agent. I was never aware of this bank statement being provided on my behalf. They did it. Do you think they can refuse it? They can absolutely refuse it. So therefore, what you should be doing is, number one, speak to the right expert, ensure that you provide right documents, and you remain honest about it. Try to document each and every conversation. Do not rely just on phone conversation. Try to document, try to make notes. What I tend to do when I speak to someone is I always take notes in the initial consultation. I try to find out the circumstances of the person. I try to write what I completely clearly communicate, what I can do and I cannot do, so that I set the expectations from the very same meeting. I hope you've gained some exposure in terms of understanding what deception can do, and I urge you to always think long term, always remain honest, and never be fearful of the things have not gone your way. It is completely acceptable. The Home Office do not expect perfect people. They want people who are of good character and who are trustworthy and credible. And the way to prove that is through your documentation and how you communicate your application. After all, the person who's sitting on the other side, who's assessing your application, is a human being. They can absolutely make mistakes. One of the things that I've not been able to accommodate is the Home Office caseworker mistakes. If you believe that they've refused visa without considering the evidence that you already provided, you should absolutely write an email back to them that in the decision that you provided, that I did not provide a statement of finances of the last 1 month was missing. You should write back to them saying, I object to the decision taken by you and I'm applying for this reconsideration because one of the grounds of refusal was this, and I believe this is factually incorrect because the caseworker made an error. I actually provided one statement. The proof of that is in your portal. You can look at that date, and the caseworker stated that they have not provided statement. If you provide explanation like this and then send them an email to reconsider my visa application form, the chances are they may grant you the visa. This is how you should approach that. As much as sometimes you can do the things yourself, it pays to get the right experts' help. If you believe that this video has helped you and educated you, do subscribe to my channel. I wanted to thank each and every one of you. You've helped me reach 300 subscribers, which I never expected, and I'm so grateful. So do subscribe to my channel and stay tuned for latest updates on the UK immigration law.